courts, in case law, courts have reached conclusions that when that happens, anything is possible. To sustain the court's objection would mean that, again, Ms. Guyger would have had to state it, well, I thought other than, he was going to hurt me or kill me, that he was also going to commit these other enumerated offenses. These offenses that are listed, Your Honor, are the types of...
Now, I do know you understand the rules of statutory construction.
Yes.
And you know what these phrases or stand for, as well as the placement of the commas in between these various offenses.
Yes, Your Honor.
So I don't think that argument is genuine. I think that's disingenuous to presume that Ms. Guyger would have had to get on the stand and say, I thought he was going to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery.
Well, no, Your Honor, I'm saying that she shouldn't have had to have done that.
And this statute doesn't presume that she would have.
Well, no,
we're going to move on from that. I'm going to reread Shaw quickly in its entirety, and I'll let you know. Your next objection, Mr. Gladden.
Yes, Judge. The state's next objection extends from the middle of page 6 to the top of page 7. This is the portion of the charge commonly referred to as the Castle Doctrine. And the state has filed an objection to the inclusion of Castle Doctrine in the jury charge. The Castle Doctrine it's a defensive issue, but it's kind of an optional part of another defensive issue. And so I think Shaw still applies. The page previously in what I provided to the court from Shaw, I think this rule still applies, that there has to be some evidence on each element of a defense that, if believed by the jury, would support a rational inference that the element is true for the defense to be included in the jury charge. And the Castle Doctrine is a defensive issue with a twist. It's a presumption in favor of the defense as opposed to just a statutory defense. And so what this court is tasked with deciding is whether I want to make sure I quote the statute accurately for the court. In Penal Code section 2. 2.05, that there has to be sufficient evidence of the facts that give rise to the presumption for the issue of the existence of the presumed fact to be submitted to the jury. Now, for Castle Doctrine, the facts that give rise to the presumption are the three parts that, one, the defendant has to know or have reason to believe either the victim had unlawfully and with force entered the actor's occupied habitation, knew or had reason to believe that the victim was attempting to remove unlawfully and with force the actor from the actor's habitation, or knew or had reason to believe that the victim was committing or attempting to commit a violent felony. 2, the defendant did not provoke the victim. And 3, the defendant was not otherwise engaged in criminal activity. There has to be sufficient evidence of the facts that give rise to that, of those three facts, to give rise to the presumption. The state's argument in this case is that there is no evidence to give rise to the first part of this presumption. There's no evidence the defendant knew or had reason to believe Mr. John had entered the defendant's occupied habitation. The defendant wasn't in the apartment when she said she formed the belief that someone had entered. The defendant never testified or gave any reason for her to believe that Mr. John was trying to remove her from the apartment. And all the defendant testified to about believing that she would be killed is, I believed that Mr. John was going to kill me. But there were no facts that would support that belief. There was no reason to believe that she would be killed. The case I've cited the court to in our objection to the Castle Doctrine is Audie v. State, where the Amarillo Court of Appeals has said that evidence of a person who's larger than the defendant, who is lunging at the defendant, and who is yelling at the defendant is at most a reason to believe that contact may occur. Contact is an assault. Contact is not a murder. There's less evidence to support a belief of an imminent murder in this case than there was in Audie. Here the victim was no more than 13 feet away from the defendant. And the victim was saying, even in the light most favorable to the defendant, the victim was saying, hey, that's it. There's no evidence that Mr. John had a weapon. There's no evidence that Mr. John brandished a weapon. There's no basis for the defendant to have reason to believe that Mr. John was committing or attempting to commit murder, much less any of the other violent felonies. So the state would object to the inclusion of the Castle Doctrine.
Mr. Mahar, do you have a response?
Yes, Your Honor. Thank you. Your Honor, the Castle Doctrine is under Penal Code Section 9.32b. It is a defensive issue. In Hamill v. State 916 Southwest 491, Court of Criminal Appeals case 1996, I'm just going to quote the holding. It is well settled that an accused has a right to an instruction on any defensive issue raised by the evidence, whether that evidence is weak, strong, unimpeached, or contradicted, regardless of what the trial court may or may not think about the credibility of the evidence. Now, the evidence showed that she believed that she was entering her apartment. There was an intruder, she believed, in her apartment. Now, whether that belief was reasonable, as you said, Your Honor, yourself, that is for the jury to decide. So we believe the 9.32b instruction should be included for the jury to decide whether that presumption is available to Ms. Guyger.
And Judge, I would disagree that Hamill applies in this case because the defensive issue is self-defense. The reasonableness question for self-defense is not the belief that it's her apartment or not. The reasonableness inquiry for the jury is whether the defendant believed deadly force was immediately necessary. The Castle Doctrine creates an almost irrebuttable presumption that that belief was reasonable if the jury finds that the facts giving rise to the presumption exist. That's why the court can't use the standard in Hamill for deciding whether the Castle Doctrine applies. Instead, there is a statutory standard for whether a presumption applies, and it's not whether there's any evidence, no matter how weak or impeached. It's whether there is sufficient evidence. And in fact, the court can go on and decide that if the court is satisfied that the evidence as a whole clearly precludes finding beyond a reasonable doubt of the presumed fact, the court can exclude the presumption even in the face of sufficient evidence. What I'm arguing to the court here is simply there is not sufficient evidence based on the statutory standard.
Can I briefly respond, Your Honor?
No, I don't need any more responses. I've read a ton of self-defense cases and issues, and the court will overrule your objection, Mr. Black.
Thank you, Judge.
And next objection, sir.
The state's next objection is at the top of page 8, at the very end of the instruction on failure to retreat. In all fairness, the court's charge, as I understand it, tracks the statutory language of failure to retreat. But the case law has approved what I call a contrary instruction that should finish by, after telling the jury that if they find the three elements of no duty to retreat, if they find the three elements, they may not consider the defendant's failure to retreat. The court can also include the converse instruction. If you do not so find, you may consider any failure of the defendant to retreat that might be shown by the evidence in deciding whether the defendant reasonably believed her use of deadly force was immediately necessary. That's included in the state's proposed charge, and the state would ask that it be included in the court's charge.
We're going to object to the inclusion of Mr. Gladden's suggested language. I think that language is confusing, and I don't believe that it's supported by the evidence. And, again, the proposed instruction, Your Honor, that you provided tracks the language exactly, the statute exactly, the language of the statute. And that's my objection.
concerning the defendant's duty to retreat is the one that has given the court the most difficulty, because presuming that the jury does not find that the mistake of fact as to being in her own apartment was reasonable, that I am wrestling with whether or not the duty to retreat should be included. So let me just think about that for just a minute. Did you have another objection, Mr. Glad?
Yes, Judge. The state's next objection is to the first full paragraph on page 8. When a person is attacked with unlawful deadly force or she reasonably believes she is under attack or attempted attack, going down to viewed from her standpoint at the time to protect herself from such attack or attempted attack. This paragraph is commonly referred to as an apparent danger instruction or a multiple assailants instruction. It's kind of a hybrid because it also says by one or more persons. Can I approach the bench again, Judge?
Sure.
I've provided the court with Beltran de la Torre v. State. It's from the Court of Criminal Appeals 2 weeks ago. So it's not yet been reported. It's numbered PD 0561-18. The apparent danger instruction, well, let me just read what Beltran says. To ensure compliance with Article 3614, a trial judge should, as a general rule, avoid including non-statutory instructions in the charge because such instructions frequently constitute impermissible comments on the weight of the evidence. At issue in Beltran de la Torre were two non-statutory instructions, one in favor of the state, one in favor of the defense, both of which the court said were non-statutory, and it told the jury what it could consider outside the realms of what the statute provided. And in both instances, the court said that those instructions drew the jury's attention to a particular type of evidence in deciding an issue, whether it was in deciding the guilt of the defendant or in deciding a defensive issue. And the court said that that was improper and constituted a comment on the weight of the evidence in both cases. The apparent danger instruction, as used traditionally in the past, would constitute the same type of instruction, because what the statute for self-defense provides is that a person is justified if they reasonably believe that deadly force is immediately necessary. A reasonable belief is defined by statute as a belief that would be held by an ordinary and prudent person in the same circumstances. What the Court of Criminal Appeals has said in Valentine v. State, and what the courts of appeals have held in applying that, is that an instruction that tracks the language of self-defense and includes the statutory definition of reasonable belief communicates to the jury the principle of apparent danger, because it's a question of what did the defendant believe and was it reasonable. But actually putting in the apparent danger instruction directs the jury's attention to a specific type of evidence, that is the standpoint of the defendant's viewpoint, without statutory authorization. The apparent danger language is not in statute, and so it should not be included in the jury charge.
Let me be clear, exactly which sentences or paragraphs are you asking to be explained?
For this objection, Judge, I'm objecting to the entire first full paragraph on page 8. And as a heads up, I'll be objecting to the next full paragraph as well, but I was going to divide that out.
So the paragraph that begins when a person is attacked.
Yes, Judge.
And you said your next objection goes to the next paragraph?
Yes, Judge, I would object to the next paragraph too, for multiple reasons, one of which dovetails from the apparent danger objection. It reads in the court's proposed charge that the next paragraph is a part of the apparent danger instruction, so I'll tie it together. The language taken from that next paragraph, the second full paragraph on page 8, appears to be taken in part from Article 3836 of the Code of Criminal Procedure. There's several problems with including that in the jury charge, especially including it here. The first is Article 3836 is not limited to the reasonableness of the defendant's belief, whether as a part of an apparent danger analysis or not. Article 3836 is a rule of evidentiary admissibility in a prosecution for murder. It's a basis for admitting certain types of evidence. It's neither a legal issue that the jury should be instructed on. It's a rule of evidentiary admissibility, and to the extent 3836 allows for specific uses of that evidence, that would be appropriately put in a limiting instruction, such as in the 404B instruction, where the jury is instructed, you may consider extraneous bad acts for the 404B purposes and the state of mind of the defendant, and for no other purpose. And that's sort of where that phrase state of mind comes from in the traditional 404B instruction. But to include it in the apparent danger instruction, especially as a full instruction, it directs the jury's attention to a specific piece of evidence without really statutory authorization for doing so. And so it's a comment on the weight of the evidence. And it applies to an apparent danger instruction, which also should not be included in the charge. So the state objects to both of those paragraphs.
Your Honor, I'll address the 3836 instruction. First off, Your Honor, that is a statutory instruction. Mr. Guyger said so. The state, Your Honor, relied on 3836, as you recall, to admit certain evidence that the defense objected to. So now the state doesn't want to use 3836 because it doesn't benefit them in the jury charge.
Judge, if I can respond to that. We don't mind.
You will.
Okay. Okay.
Second, Your Honor, the case that Mr. Guyger handed to Beltran del Torre, on page 11, star 11, I don't know where it is, Your Honor, on what he handed you on the state's page star 11, the Court of Criminal Appeals continues and makes an exception to what they discussed as a rule. It's not a new rule of case law, Your Honor. But the court said a jury charge may properly include definitions for non-statutorily defined terms that have a known and established legal meaning or have acquired a peculiar and appropriate meaning in the law, as where the words used have a well-common law meaning. Apparent danger, Your Honor, fits right in the parameters of the discussion of the Court of Criminal Appeals of the exception they made in Beltran del Torre. Such terms are considered as having been used in their technical sense. It is not error for the trial court to include a precise, uniform definition to guide the jury's deliberations. Your Honor, these two paragraphs do not divert the jury's attention to any particular evidence. I know Mr. Guyger said it does, but he hasn't identified what that evidence is that would make it an improper weight of the evidence or comment on the weight of the evidence by the court. So we believe that both those paragraphs are allowed by the court, Your Honor. The second one is statutory. The first one is allowed as an exception in Beltran del Torre, and we ask the court to overrule the state's objections.
Judge, the exception in Beltran del Torre deals with words that are used in the jury charge that may have a risk where jurors may arbitrarily apply an inaccurate definition to the term if it doesn't otherwise have a statutory meaning. The issue in the law and the jury instruction in this case is not apparent danger. Apparent danger doesn't appear in 931 or 932 of the Penal Code. The jury is not being asked whether there was an apparent danger. So no definition or application of apparent danger needs to be applied. The jury is being asked whether the defendant had a reasonable belief that deadly force was immediately necessary. And the term reasonable belief is defined in the court's charge, and it tracks the definition of reasonable belief that's in the Penal Code. So there is no undefined term that is taken on a special legal meaning that the jury may misapply. So the exception outlined in Beltran de la Torre is not at issue here. The use of 3836, what I interrupted Mr. Mulla to add is one of our objections is that the word state of mind should be added to the list of permissible uses in the court's 404B instruction later in the charge, I believe on page 13. So that would adequately account for what Mr. Mulla just argued, because the jury will be told that if they find that the extraneous acts by the defendant were done, they may consider them for the purpose of deciding the defendant's state of mind, which is a permissible use under 3836, but it ties it into the limiting instruction under 404B as a proper instruction for the jury.
So you want to tie that into my limiting instruction that begins on page 12, the last paragraph that begins on page 12, and continues to, oh, I'm sorry, I guess the first paragraph on 13, which begins even then.
Yes, Judge, it could read, even then you may only consider the same in determining the defendant's motive, opportunity, intent, plan, identity, knowledge, or absence of mistake or accident, comma, or state of mind, if any, and not for any other purpose.
That's overruled. Next.
Judge, the state's next objection is on page 9 in the application paragraph for self-defense. About halfway down, this application paragraph incorporates the apparent danger instruction as included on page 8. That language, just as it is in the abstract, is non-statutory. It's an improper comment on the weight of the evidence. It misinstructs the jury on the applicable law, and the state objects to its inclusion in the application paragraph.
That's overruled as well. Next.
The state objects to the final paragraph on page 9, all of page 10, and the first paragraph of page 11. This is the jury instruction on mistake of fact. And Judge, this is really the crux of this case. And when I say the crux of the case, I don't mean that the state thinks that mistake of fact decides whether the defendant is guilty. This is the crux of the case because this instruction on mistake of fact is wholly inapplicable to a charge of murder based on the evidence in this case. The evidence in this case is that the defendant, viewed in the light most favorable to the defendant, the evidence is that the defendant was mistaken about where she was. The evidence is wholly undisputed about what the defendant intended to do. Murder is a result of the conduct offense. And so the intent element of murder goes to the result, causing the death. No one has disputed that the defendant intended to cause Mr. John's death. The dispute has been over where the defendant believed that she was. The case law is clear that mistake of fact...
Is that the only dispute?
Pardon, Judge?
You think that's the only dispute?
As it goes to mistake of fact.
Okay. Sorry.
The defense of mistake of fact, which is in Chapter 8 of the Penal Code, says that it is a defense to prosecution that the actor through mistake formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for the commission of the offense. The kind of culpability required for the commission of the offense is the culpable mental state. The Court of Criminal Appeals has made that crystal clear. So unless there is a mistaken belief about the kind of culpability, about the culpable mental state for murder, mistake of fact does not apply to this case. And the court has a duty to charge the jury as to the law applicable to the case. Mistake of fact is not applicable to this case unless there's a dispute about whether the defendant intended to cause a death, not about whether the defendant thought she was in her own apartment. And what I want to draw the court's attention to is the application paragraph of the mistake of fact instruction as presented to the jury. To decide the issue of mistake of fact, this is on page 10, you must determine whether the state has proved beyond a reasonable doubt one of the following. 1, the defendant did not believe that she was entering her own apartment or did not believe that the deceased was an intruder in her apartment. Or 2, the defendant's belief that she was entering her own apartment or her belief that the deceased was an intruder in her apartment was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either 1 or 2 listed above. You need not agree on which of these elements the state has proved. This instruction tells the jury that for a result offense, that even if the jury believes that the defendant intended to kill Mr. John, that if she was mistaken about where she was, that the jury should acquit her. And Judge, that's not the law. And number 1 says that the state has to prove a disjunctive. The state has to prove beyond a reasonable doubt the defendant did not believe she was entering her own apartment or did not believe the deceased was an intruder in her apartment. How does the jury know which one of those they have to decide, and how do they apply that to the result of the defendant's conduct? This instruction confuses the jury. It applies inapplicable law that does not apply to this case. It's an improper comment on the weight of the evidence because it's directing the jury to consider the defendant's belief about where she was to her intent to kill. And so this jury instruction should not be in this charge, Judge, and the state objects to it.
Thank you, Your Honor. Your Honor, the mistake of fact instruction doesn't simply go to whether the defendant is mistaken as to the essential elements of the offense when there's a defensive issue involved. In a case where a defensive issue like self-defense, defense of property, defense of a third person is involved, the standard to prove beyond a reasonable doubt that the offense occurred is actually under Saxton versus State, 804 Southwest 2nd, 910. And Saxton makes very clear that if a defensive issue is raised, the state bears the burden of persuasion to disprove the defensive issue. The state must still prove the case beyond a reasonable doubt as to both the essential elements of the offense, your murder or manslaughter, and of the defensive issues. The mistake of fact, Your Honor, obviously has to apply. It only makes sense that it applies if Ms. Guyger was mistaken in her belief, not only whether she was at the right apartment or not, but whether there was an actual intruder in what she thought was her apartment. May I approach, Your Honor?
Yes.
The tender to the court, Your Honor, Guyger versus State, that is a murder case. I'm going to give a copy to Mr. Gladden. Your Honor, Guyger involves a situation where a couple of guys left a Dallas nightclub. They were bounced out of a Dallas nightclub, and they were angry about it. One of the guys, not Mr. Guyger, but one of his friends, saw a vehicle that he thought belonged to some guy he didn't like. So according to the evidence that was presented, the other guy shot a couple of rounds into the vehicle. Mr. Guyger did the same thing. He says he thought the vehicle was empty. As it turns out, there was someone in the vehicle and that person was killed. And as the Court of Criminal Appeals discusses, whether Mr. Guyger's mistaken belief that there was someone inside the vehicle, which would have obviously made an intentional knowing killing, whether that belief was reasonable was the issue for the jury to decide. Now, it may be unreasonable, it may be implausible, but because Mr. Guyger raised the factual issue, Was there someone in the vehicle? Because obviously, Your Honor, if there was no one in the vehicle, he would have just damaged property by shooting into a vehicle. But there was someone in the vehicle, and unfortunately a person was killed. But the point of the Court of the Criminal Appeals, Your Honor, is that, again, Mr. Granger thought there was no one in the vehicle, there was someone in the vehicle, someone was killed as a result of his action, so therefore he was mistaken in his belief that there was someone in the vehicle. So that was an issue that the jury should have decided. So, Your Honor, if a person for a reason that silly shoots into a vehicle, but believing that there's no one there, but in fact if someone was, and he's entitled to a mistaken fact instruction, Ms. Guyger should be as well. And although it is a concurring opinion, Your Honor, although it is a concurring opinion, Judge Keller does discuss that there should be very limited situations where if the evidence is raised that there could have been a mistake of fact as to either the essential elements or, as other case law shows, a defensive issue, the jury should be the entity deciding whether that is an issue. The 802 issue should be applicable to the case. That's it, Your Honor.
And Judge, a belief that a car is empty, shooting into a car you believe is empty, negates your intent to kill a human being. If you don't believe there's a human being in the car, how can you have an intent to cause a death? This is not the factual situation in this case, Judge. The defendant testified she believed there was someone in her apartment. There was someone in what turned out to be his apartment. She pointed the gun at him. She shot center mass. There is no dispute here that she was shooting at a human being and intended to cause his death. So Granger does not apply to this situation. And to say that mistake of fact is a defensive issue that should then apply to another defensive issue is inappropriate. I don't know if this court is familiar with the commentary in the Texas pattern jury charges, but the committee there pointed out that mistake of fact as a defense, the way it's worded, because it applies to the culpable mental state, it's basically a no mental state defense. And ordinarily a no mental state defense is a failure of proof defense that should not be included in the jury charge. It's provided for as a statute, so it should be included if raised. But there is no basis for taking one statutory defense and incorporating it into another statutory defense. And in this case, the charge doesn't even do that. The charge doesn't apply mistake of fact to the justification of self-defense. It instructs the jury if you find that she was mistaken, that she was reasonably mistaken about where she was, you will acquit her. It eliminates her legal culpability for an intentional killing based on her mistake about the circumstances. And Judge, that's just not the law, and the state objects to that charge.
The court is going to leave this to the jury to decide as the trier of fact as to whether or not a mistaken belief is reasonable. So that objection is overruled. Your next one, Mr. Glad.
Judge, the state additionally objects to the second full paragraph on page 11. It is an additional part of the application paragraph for mistake of fact. So the state would object to that as well.
Overruled.
The final objection the state has, Judge, is on page 13 of the court's charge. That first paragraph that we discussed previously, beginning, even then you may only consider, the state asks that state of mind of the defendant be added to the list of permissible purposes for consideration of extraneous bad acts. Because, Judge, that was the reason why the state moved to admit that evidence was in addition to the listed uses under 404B, which is a non-exclusive list. The state specifically argued that that evidence was relevant to the state of mind of the defendant.
Is that your last objection?
Yes, Judge.
Mr. Mullen?
No objection, Your Honor.
state of mind following accident.
Yes, Judge.
I think the only other things I was left to consider was whether or not we will have a recitation of the various felony offenses that someone might protect themselves against. It's aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Right?
Yes, Judge, and
You wanted all of the other crimes omitted except for murder.
yes, and that's both in the elements of self-defense on page 6, and to the extent the court is leaving in Castle Doctrine, it's the same list on page 7. And then additionally, there was the additional language for the instruction on failure to retreat.
I'm going to leave that recitation of other felony offenses. I think that was your objection 3 and 5, is that correct? So those objections are overruled. I need to make a correction to add state of mind. And how, well, oh, I'm sorry, Mr. Muller, did you have any?
Oh, no, I'm sorry, but I was just, no, nothing further, Your Honor.
Okay. Did you have any objections to the charge?
No objections from the defense, Your Honor.
So I need to add state of mind on page 13. How long would you all like to argue?
No more than an hour.
Perfect. That's exactly what I was hoping for. I'm assuming you are splitting your time.
Yes, ma'am. Mr. Fine will open, I will close.
Mr. Fine will open. Mr. Fine, would you like a warning of some sort?
Yes, Your Honor. I'll use 20 minutes. Will you let me know, please?
After 20 minutes.
Yes, Your Honor.
And Mr. Hermes, what kind of warning, if any, would you like?
Would you let me know, Judge, when I've got 5 minutes left?
5 minutes remaining. Mr. Rogers, how will you use your time? Will you do all of the arguing?
No, Your Honor. We're going to split it. Mr. Shook will open.
Sorry.
Sorry, Judge, we're talking among ourselves. The
I
microphone's
know.
on.
Yeah, I hear a lot of talking you all do. Sometimes it's interesting. Okay, Mr. Shook, you will open.
Yes, Your Honor. You
And
can just tell me when I've used 30 minutes.
after 30.
Thank you.
And I'm assuming you're closing, Mr. Rogers?
Yes, Your Honor. If I could just get a 5-minute warning.
I'm just going to tell you, if you go over your time a little bit, unless it becomes excessive, I'm not going to interrupt you. But however far you go over, I will add it to Mr. Hermes.
Yes, ma'am.
And I need to tell both of you, just so you don't accuse me of cheating on the clock, when you first get up and start your salutations and thanks and all of that, I don't generally start the clock until you get to the substance of the matter. Although I need to bring the clock out here, my phone. So I am assuming you all want a quick bathroom break, and I need to make one change or addition in here. No, I'm not going to print another copy. You can all turn to page 13 and add the word state of mind. don't want to kill another tree, but I will reprint at least my page 13 and add state of mind. Hopefully that won't take us over to the next page. It shouldn't. So your charges should still look identically to mine. And so I'm assuming you guys want a quick break. I need a quick break to fix this.
Yes, ma'am.
So let's bring the jury in at 10:15. I neglected to say that I was adding the definition for act. Okay? So I made those 2 changes. Is everybody ready?
Yes, Your Honor. Yes, Your Honor.
Ask them to-
All right.
Thank you. You all may be seated. Good morning, everyone. Good morning. Let me apologize for the delay. Mr. Is the state ready to proceed?
State's ready.
Defense counsel, are you ready as well?
Defense is ready, Your Honor.
Mr. Rogers, please call your next witness.
Your Honor, ladies and gentlemen, the jury, the defense rests.
What says the state?
Your Honor, the state closes.
Defense will close, Your Honor.
Thank you. That being said, ladies and gentlemen, you've heard all of the evidence that you will hear in this case. At this time, it is my responsibility to read to you the jury instructions. You don't have to memorize what I'm telling you. You'll be able to take these back into your juror room to use during your deliberations. And following my recitation of these instructions, the parties will have closing arguments for you. Jury instructions. Members of the jury, the defendant, Amber Guyger, stands charged by indictment with the offense of murder alleged to have been committed on or about September 6, 2018 in Dallas County, Texas. To this charge, the defendant has entered a plea of not guilty. A person commits the offense of murder if the person, 1, intentionally or knowingly causes the death of an individual, or 2, intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. A person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Person means an individual, corporation, or association. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or B, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Now, considering all the law contained in the court's charge, in Dallas County, Texas, the defendant, Amber Guyger, did intentionally or knowingly cause the death of Botham John, an individual hereinafter called deceased, by shooting the deceased with a firearm, a deadly weapon, or if you unanimously find and believe from the evidence beyond a reasonable doubt that on or about September 6, 2018, in Dallas County, Texas, the defendant, Amber Guyger, did intend to cause serious bodily injury to Botham John, an individual hereinafter called deceased, and did commit an act clearly dangerous to human life by shooting the deceased with a firearm, a deadly weapon, thereby causing the death of Botham John, then you will find the defendant guilty of murder as alleged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will next consider whether the defendant is guilty of the included offense of manslaughter. Our law provides that a person commits the offense of manslaughter if she recklessly causes the death of an individual. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Now, therefore, considering all the law contained in the court's charge, if you unanimously find and believe from the evidence beyond a reasonable doubt that on or about September 6, 2018, in Dallas County, Texas, the defendant, Amber Guyger, did recklessly cause the death of Botham John, an individual hereinafter called deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. If you should find from the evidence beyond a reasonable doubt that the defendant is either guilty of murder or manslaughter, but you have a reasonable doubt as to which offense she is guilty of, then you should resolve that doubt in the defendant's favor and find the defendant guilty of the included offense of manslaughter. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, you will acquit the defendant and say by your verdict, not guilty. It is a defense to prosecution that the conduct in question is justified under our law. You are to consider the statutory defense of self-defense in determining if the defendant is guilty of the offenses alleged or included in the indictment. Under our law, a person is justified in using force against another in self-defense when and to the degree she reasonably believes the force is immediately necessary to protect herself against the other's use or attempted use of unlawful force. The use of force against another is not justified in response to verbal provocation alone. A person is justified in using deadly force against another if she would be justified in using force against the other as set out above, and when she reasonably believes that such deadly force is immediately necessary to protect herself against the other person's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. The term reasonable belief as used herein means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. The term deadly force as used herein means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Habitation means a structure that is adapted for the overnight accommodation of persons and includes A, each separately secured or occupied portion of the structure, and B, each structure pertinent to or connected with the structure. The defendant's belief that deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had reason to believe that the person against whom deadly force was used unlawfully and with force entered the actor's occupied habitation, or knew or had reason to believe that the person against whom deadly force was used was attempting to remove unlawfully and with force the actor from the actor's habitation, or knew or had reason to believe that the person against whom deadly force was used was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated murder. And the person did not, the defendant did not provoke the person against whom the deadly force was used, and the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the deadly force was used. This presumption applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption as listed above do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, you must find that the presumption exists. Even though you may find that the presumption does not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged. A person who has a right to be present at the location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force to defend herself. If you find from the evidence that the defendant was such a person, or if you have a reasonable doubt thereof, you may not consider whether the defendant failed to retreat in determining whether the defendant reasonably believed that the use of deadly force was necessary. Excuse me. When a person is attacked with unlawful deadly force, or if she reasonably believes she is under attack or attempted attack with unlawful deadly force by one or more persons, and there is created in the mind of such person a reasonable expectation or fear of death or serious bodily injury to herself at the hands of such attacker or attackers, then the law excuses or justifies such person in resorting to deadly force by any means at her command to to the degree that she reasonably believes immediately necessary, viewed from her standpoint at the time, to protect herself from such attack or attempted attack. In making your determination, you should consider all the facts and circumstances and evidence before you, all relevant facts and circumstances surrounding the use of force or deadly force, the previous relationship existing between the defendant and the injured party, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense. In considering such circumstances, you should place yourselves in the defendant's position at the time and view them from her standpoint alone. Now, if you find from the evidence beyond a reasonable doubt that on or about the 6th day of September 2018 in Dallas County, Texas, the defendant, Amber Guyger, did intentionally or knowingly cause the death of Botham John, hereinafter called deceased, by shooting the deceased with a firearm, or did intend to cause serious bodily injury to Botham John, and did commit an act clearly dangerous to human life by shooting the deceased with a firearm, a deadly weapon, thereby causing the death of Botham John, or did recklessly cause the death of Botham John by shooting Botham John with a firearm, but you further find from the evidence, or you have a reasonable doubt thereof, that at the time of the alleged offense, the defendant reasonably believed that she was under attack or attempted attack with unlawful deadly force from Botham John, and that the defendant reasonably believed, as viewed from her standpoint, that such deadly force as she used was immediately necessary to protect herself against such attack or attempted attack, or to prevent the imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery by Botham John. And so believing, she shot Botham John with a firearm, a deadly weapon. Then you shall acquit the defendant and say by your verdict, not guilty. A person's conduct that would otherwise constitute the crime of murder or manslaughter is not a criminal offense if the person through mistake formed a reasonable belief about a matter of fact, and the mistaken belief negated the kind of culpability required for the commission of the offense. The defendant is not required to prove that she made a mistake of fact. Rather, the state must prove beyond a reasonable doubt that the defendant did not make a mistake of fact constituting a defense. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. If you have found that the state has proved the offense beyond a reasonable doubt, you must next decide whether the state has proved the defendant did not make a mistake of fact constituting a defense. To decide the issue of mistake of fact, you must determine whether the state has proved beyond a reasonable doubt one of the following. 1. The defendant did not believe that she was entering her own apartment, or did not believe that the deceased was an intruder in her apartment, or 2. The defendant's belief that she was entering her own apartment, or her belief that the deceased was an intruder in her apartment, was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either 1 or 2 listed above. You need not agree on which of these elements the state has proved. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or element 2 listed above, you must find the defendant not guilty. If you unanimously agree that the state has proved beyond a reasonable doubt each of the elements of murder or manslaughter, and you unanimously agree that the state has proved beyond a reasonable doubt either element 1, that the defendant did not believe that she was entering her own apartment, or did not believe that the deceased was an intruder in her apartment, or element 2, that the defendant's belief that she was entering her own apartment, or that her belief that the deceased was an intruder in her apartment was not reasonable, then you shall find the defendant guilty as alleged or included in the indictment. You are instructed that when reading the instructions contained in this charge, you are to consider the charge as a whole. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the issue of guilt of the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are instructed that if there is any testimony before you in this case regarding the defendant having committed offenses or acts other than the offense alleged against her in the indictment in this case, you cannot consider such testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses or acts, if any were committed. And even then, you may only consider the same in determining the defendant's motive, opportunity, intent, plan, identity, knowledge, or absence of mistake, accident, or state of mind, if any, and not for any other purpose. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict, not guilty. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. Mere sentiment, conjecture, sympathy, passion, prejudice, public opinion, or public feeling is to play no part in your deliberations. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given their testimony. But you are bound to receive the law from the court, which is given to you in this charge. After argument of counsel, you will retire to consider your verdict in this case. You should begin by selecting one of your members as presiding juror. It is the duty of the presiding juror to preside at your deliberations, to vote equally as any other juror in arriving at a verdict, and to sign the verdict on behalf of the jury. After you retire to consider your verdict, no one has any authority to communicate with you except the officer who has you in charge. During your deliberations in this case, you must neither consider, discuss, nor relate any matters not in evidence before you. You should neither consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. After you have retired, you may communicate with this court in writing through the bailiff who has you in charge. Your written communication must be signed by the presiding juror. No one has any authority to communicate with you except the bailiff who has you in his or her charge. Do not attempt to talk to the bailiff, the attorneys, or the court regarding any question you may have concerning the trial of this case. After you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall and one of the bailiffs will respond. Signed, Judge Tammy Kemp, 204th Judicial District Court, Dallas County, Texas. And the last 2 pages consist of the verdict forms, and you will select only one of them. The first reads, We, the jury, unanimously find the defendant, Amber Guyger, guilty of murder as charged in the indictment. And then there's a signature line for the presiding juror to sign his or her name, and then there's a line for that person to print their name. Or, we, the jury, unanimously find the defendant, Amber Guyger, guilty of manslaughter as included in the indictment. The same two lines for the presiding juror to put their name. And lastly, we, the jury, unanimously find the defendant, Amber Guyger, not guilty, in the same two signatory lines. What says the state?
Students ready? May it please the board,
Yes.
counsel. Ladies and gentlemen of the jury. I never want anybody to ever have to go through or even imagine going through what I felt that night. That was one of the very last things the defendant said when she was on the stand. Are you kidding? That is garbage. Most of what she said was garbage. 99% of this trial has been about the defendant. So let's take 1 minute to talk about that. You know, when you're done with a hard day, we've all been there. And whether you eventually sit down on your couch or your favorite chair or lay down in bed, it finally hits you, right? I can breathe. You have that moment of peace, right? We've all been there. You guys have probably been there this whole trial. We get back to the hotel. That's what Bo was trying to achieve on September 6th, 2018. You know that because you look at that ottoman and you see that he's got his bowl of ice cream that he's finally going to get to enjoy. He's got his remote there. He's got his cell phone there. He's got his laptop there, and right in front of him is that TV. I don't know if Bo got to enjoy that for 1 second, or 5 seconds, or 10 seconds, but it wasn't long because the ice cream was still frozen. When all of a sudden, this defendant busts into his apartment, what must Bo have been thinking? He's sitting on the couch and he acts like a normal, reasonable person. And he looks in the direction of the intruder into his home. She is an intruder into his home. He looks like a normal, reasonable person. He starts to get up like a normal, reasonable person who has somebody busting into their home. And before he can even get up, he is shot dead in his own home. By her. A guilty verdict in this case does not mean you hate police. This has got nothing to do with politics. And let me tell you something. The majority of police officers do a great job. They do a great service for us. We saw multiple police officers here that tried to save Bo's life, right? Those were good police officers. A guilty verdict is not saying you don't like police. This has nothing to do with that. This has to do with that defendant making unreasonable decisions that put her in that seat and Bo in the ground. That's what this case is about. On September 6th, 2019, 1 year after this happened, y'all all came down to the central jury room. Remember that? You guys had to fill out that 5-page questionnaire. We sent out 4,000 jury summons, and about 800 people responded. You 16 were one of those 800. From those 800, about 450 people filled out questionnaires because 350 people couldn't do it right off the bat for various reasons. After you guys left on the 6th, we all looked at those questionnaires for a week. We studied those questionnaires. We looked at every single answer, and we determined about 200 and something of y'all, not y'all, but the other people who were there, couldn't serve either because you couldn't follow the law. We were at 220 people the last time I spoke to y'all on September 13th. And remember what I told you guys. I was very clear in what our intentions were. I said we were going to prove our case beyond a reasonable doubt, and I gave everybody an out at that point. If you can't do it, if you don't have the stomach for it, let me know right now. And plenty of people raised their hands. Plenty of people said they couldn't follow the law. Plenty of people couldn't do it. You 16 told me you could. You said you would follow the law. You said when we proved our case beyond a reasonable doubt, you would find her guilty. Not beyond all possible doubt, beyond all reasonable doubt. And you're going to hear me say reasonable a bunch. You're going to hear Mr. Hermes say reasonable a bunch, because this case is all about what is reasonable and what is absurd. Let's talk about witness credibility. We talked about that as well, remember? We talked about the fact that this defendant was a police officer at the time of the offense. You guys all assured me she's not going to get a leg up about that. You're going to treat her the same as anybody else. You assured me, each and every one of you, that you would do that. I expect you to follow through with that. You assured me if she took the stand and waived her Fifth Amendment rights, you would treat her the same as any other witness. You would judge her credibility the same as any other witness. She sat up here and told you 2 different stories. She couldn't even get her story straight because we go all the way through direct and we go all the way through cross. And the story is, oh, yep, Bo's at the back door and he's coming at me and I had no choice. I get to 13 feet and I just shoot him as he's standing there. Then all of a sudden, on redirect, oh, no. He was actually kind of over by the couch in that area. Because Mr. Hermes had brought up the physical evidence, which is that second shot in the wall over by the couch. She was caught in a lie. You know how you know Bo wasn't at the back door? Go take a look at the pictures. See if you see a little object by the back door. It's a baseball bat. You think anybody in their right mind, with somebody busting through their apartment who's standing right next to a baseball bat, doesn't pick it up? That baseball bat was never touched because he wasn't at the back door. There's no reason he ever would have been at the back door. He was sitting there getting ready to eat his ice cream. Imagine him going into that kitchen, grabbing that ice cream, putting it down, sitting down, and all that happened. That makes sense. That's reasonable. The physical evidence. He's laying right by the couch. He has no pockets. She says she's looking for his hands. He has no pockets. Even if he's coming towards her, his hands are going to be out. But where his hands were getting up off that couch. That's where they were. You guys all know that's the truth. You know it. We went through a bunch of law during jury selection. Remember I told y'all if there's a scintilla of evidence that gets in the charge. Let me tell you something. There's a lot of stuff in there. There's a lot of language and a lot of stuff, and guys, it is nonsense. So I'm going to take you through why exactly all their defenses fail. Mistake of fact, all right? Here's your run-of-the-mill hypothetical about a mistake of fact, all right? Guy goes out hunting. He's going to hunt a deer, all right? He thinks he shoots a deer. He ends up shooting a person who's dressed as a deer. That's a mistake of fact. That's a mistake of fact. This scenario is not a mistake of fact. So we must prove to you beyond a reasonable doubt. Either number one, the defendant did not believe that she was in her apartment, entering her apartment, or that Bo was an intruder. Hey, she believes that. You can believe of all kinds of crazy stuff. I could believe I'm in Florida right now. Doesn't mean I'm reasonable, so fine, just cross that out. Or the defendant's belief that she was entering her apartment was not reasonable. Because remember, it's not what the defendant thinks, because every defendant thinks they're justified. And if every defendant comes in here, if I shoot Mr. Hermes right here in the head, and I say, oh, his red tie turned into a gun, well, I guess, I got to be not guilty. That's not how it works. So let's go through about why her belief was not reasonable about entering her apartment. And you know what's beautiful about this? We had all these people come down here from the South Side Flats. We had these people, the lawyer said, oh, he went into the apartment on floor 2 and he walked in and there was a purse and a lady and all this. Who cares? Who cares? Okay, people parked on the wrong floor. People went to the wrong door. One, nobody ever shot anybody before. And two, let's talk about Miss Rose. You want to talk about somebody in the same similar situation without the defendant's training. Let's talk about Miss Rose, who was the next door neighbor, 1380, next door to the defendant. She told you about the time she went on the 4th floor, right? She went down that hallway, she turned left, she didn't see that plant or whatever that thing is, right? The noticeable deal, the urn, the plant, whatever it is. She said, that's not there anymore. Well, maybe the homeowner put it in. She walks down to her apartment. Hey, my floor mat isn't there anymore. That's strange. Maybe the apartment complex took it up, right? The smell isn't right either. You know what? Maybe I'll use my eyes, look up at the apartment sign. Oh, I'm at the wrong place. Let's compare that to the trained professional over here, the defendant, who backed into a parking spot. Look at her perspective. She is looking out at the roof line. She is backed in front of the elevator. She's looking at the roof line. She's looking at the emergency exit sign. She's looking at the elevator, and she says she's there for a couple minutes. I don't know what to believe and what not to believe from her. Let's say it's a couple seconds. Let's say it's a couple minutes. She doesn't notice any of that. Terrific. Fine. She walks down the hall. All right, now she makes the left turn. She doesn't notice the plant at all. And then she gets to Beau's apartment. All right? Look. She is standing at Beau's door, and there are 5 things that she missed right there. 1, the apartment number. Okay? Look up a foot. Not that difficult. Can't do that? Look down at your feet. You're standing on a bright red mat. Can't do that because your eyes don't function up or down? Well, guess what? When you're putting the key in the hole, your eyes have to be looking somewhere, right? She doesn't see the red blinking light. Oh, maybe her eyes aren't working. Well, how about her ears? She doesn't hear the whirring noise of the thing turn. But now her ears aren't working. All right, what about the sensation from going to concrete to carpet? You can tell the difference, and you know how you know she can tell the difference? She said that she felt when she was standing on the threshold, so she could tell the difference between metal and concrete, but not floor and concrete? That's absurd. It is absolutely absurd. Oh, and then, all right, let's open up the apartment and then get hit with this cloud of marijuana smoke so thick that Ranger Armstrong said 2 days later it reeked of marijuana. So her eyes aren't working, her ears aren't working, her sense of touch isn't working, her sense of smell isn't working. I mean, my God. This is crazy. It was unreasonable. She should have known she was in the apartment, in the wrong apartment. Oh, and how about everything once she gets into the apartment? Stuff missing, the ottoman, all that stuff. This is a trained professional. Think for 1 second. Use your brain like a normal, reasonable human being. Okay, and if you don't want to do that, and by the way, 6 of you can agree on the first belief, and 6 of you can agree on the second, because it's ors. All right, fine. Her belief that Beau was an intruder in her apartment. Yep, because most burglars, what they love to do, they break in without using any force at all. We'll get to that in a second. And then you know what they like to do? They like to plop down on your couch, have themselves some ice cream, smoke some weed, and watch some TV. Yeah. That sounds like a pretty dangerous person. I can't believe I'm even making these arguments. It's so common sense, and when you start talking about it, it sounds so absurd. All the things that she missed, and all the things that she thought. And yeah, she thinks it. But she is not a reasonable person. She was not thinking like a reasonable person that day. All right. So now we get to the point where she's in the apartment. Self-defense. We talked about this as well, right? 3 prongs, and she's got to hit all 3. All right? Yes or no? You answer these questions. The defendant was protecting herself against Beau's use or attempted use of unlawful deadly force, or to prevent the imminent commission of all these various violent felonies. Murder, aggravated sexual assault, apparently he was going to try to rape her, aggravated kidnapping. I mean, there's just all this garbage in there. All right, but let's talk about this. Let's talk about Beau's attempted use or unlawful use of deadly force. He is sitting on his couch eating ice cream. He's not going to throw the ice cream at her and kill her. He's not going to throw a spoon at her and kill her. He's sitting there the same as y'all are. You guys apparently are all posing deadly threats right now. So that fails. And if that one fails, the whole rest of it fails. But if somehow you think, well, eating ice cream, that seems like a deadly force to me. All right, go on to number 2. There was a reasonable belief based on a reasonable person standard, not what she thinks. That use of deadly force was immediately necessary. Not 3 seconds before, not 3 seconds later. At that instant, when she shot him. It had to be done. It had to be done because Beau had the audacity to think, what is going on around here? And he tried to rise up off his couch. Well, there's nothing else that could have been done. Had to have been shot dead right there. And I'll tell you another thing. She made that decision outside the door. She made that decision outside the door. She was going to go in commando style and just execute whatever was in there without thinking. And that's not reasonable either. She had other options. She could have retreated, and you can use that against her under certain circumstances. One being, she didn't have a right to be there. Another being, she provoked all of this. You can use that against her. Somehow you think it had to be done right then? All right, number 3, proportionality, equal force. We talked about somebody slaps you in the face, you can't shoot him in the head. He's eating ice cream on his couch. So if you're sitting and eating ice cream, you get shot in the heart. Is that what we're saying? Castle Doctrine. This, in a case full of bizarre things that I have to go over that I never thought in my career I'd have to talk to you guys about with this absurdity and unreasonableness of her, Castle Doctrine. Who does Castle Doctrine protect? Homeowners. It protects homeowners against intruders, and now all of a sudden the intruder is trying to use it against the homeowner. What are we doing? This presumption is if the defendant knew or had reason to believe, all right, even higher than the other one, that Beau unlawfully and with force entered. Force. Where's the force? There's no broken door. There's no hinges. There's nothing like that. There's a door that's cracked open. That's not force. So if somehow you think Castle Doctrine applies, there's no force. All right. Force entered or was attempting to enter unlawfully the defendant's occupied habitation. Occupied habitation, she lives alone. We talked about this. This is for the intruder barging in on Beau. That's what this is. Intruder barges in on Beau. Beau has the right to shoot that person under Castle Doctrine. Not the other way around. There's other parts that are in there too about that he was trying to force her out of her apartment. Oh, and by the way, defendant's occupied habitation. Let's not bury the lead. It's not her apartment. Let's not lose sight of that common sense. You know, sometimes when you're dealing with these absurdities and things that don't make any sense, you lose your own sense as well. Don't let that happen to you. It's It's not her apartment. There's no force. It's not occupied. She don't get Castle Doctrine. No. This law is not in place for her. It's in place for both. So here's what you're left with when you knock out all those defenses. You're left with one question. The question is this: is it manslaughter or is it murder? That's what you got to decide. Is it manslaughter or is it murder? Now remember, we talked about that as well. Murder does not involve premeditation. She didn't have to decide going in there, I'm going to kill him. There doesn't have to be any motive. There doesn't have to be any conspiracy behind it. All right? Murder is intentionally or knowingly causing a death or intending to cause serious bodily injury and committing an act clearly dangerous to human life. She got on the stand and told you what her intent was. Her intent was to kill. That's murder. All that stuff leading up to the door doesn't matter for the shooting. All this stuff leading up to the door doesn't matter for self-defense in terms of what's immediately necessary, and it doesn't matter murder versus manslaughter. Now look, if somehow you heard the testimony different than I did, or you see the evidence different than I did, I can argue all day, and I'm not going to be able to change your mind if you think that shooting somebody in the heart and getting up here and admitting that that was your intent. If you think that's a reckless shooting, I can't do anything with that. All right?
You've used 20 minutes.
Thank you, Your Honor. You understand our position. You understand that she admitted what her intent was. But I'll tell you one thing. This is not acquittal. It's murder versus manslaughter. And it's murder. Manslaughter might have been if that second shot that she fired through the wall hit somebody down the block walking around. Maybe that's manslaughter. Maybe. Although I'd still argue that's not clearly dangerous to human life. But you know what? Thank God that bullet didn't hit anybody as she's going in there just guns blazing. The defense is going to come up here in a few minutes. They're going to talk to y'all. And I want you to think about a few things when they talk to you guys. Every time that they mention the word mistake, I want you to think about Ms. Rose and about what is reasonable and what she did and the signs that she saw that this defendant did not see. It's not a mistake. It's a series of unreasonable decisions. She did not think that night. When they talk about deadly force, and she had to use deadly force because that was what was going on in her mind. You think about Bo about to eat some ice cream and ask yourself, is Bo a threat? Because you know what? Nobody was going to die that night. To these facts, and render the only true verdict, the only just verdict. And that is that this defendant murdered an innocent young man in his home.
Police board, counsel, members of the jury. First thing I want to do is thank you for your patience and your service and your sacrifice. This service, as all jury service, is obviously a sacrifice. You're torn from your families and your work. You have to come down to court. But in this case, it's been even a greater sacrifice because you've been sequestered because of the type of case this is. Been away from your families at nighttime too, and we thank you for that because we can make you come down here and you can get on the jury, but we can't make you pay attention to the evidence. But you all been very attentive, you all been very patient, you've listened to the evidence because you know how important this case is. Besides life or death, and the law allows someone that if a reasonable person in that position could believe their life is in danger, they can exercise it. And the court is clear and has included those instructions to you. And you'll have them back there that you can go over. But I want to emphasize this to you. When a person is attacked by unlawful deadly force, or she reasonably believes she is under attack or attempted attack by unlawful deadly force, one or more persons, and there is created in the mind of such a person a reasonable expectation of fear of death or serious bodily injury to herself at the hands of such attacker or attackers, then the law excuses or justifies such a person resorting to deadly force by any means at her command to the degree she reasonably believes it may be necessary, viewed from the standpoint at that time to protect herself from such an attack. In considering such circumstances, you should place yourself in the defendant's position at the time and view them from her standpoint alone, because the law recognizes that mistakes can be made. It's always tragic. The law is not perfect. It's tragic. But you have to follow this law. We went over this in jury selection. I wanted to make sure that everyone could follow it. Jurors that couldn't aren't on this jury. 16 of you said you could, and recognize how this situation might happen. We hear about these incidents sometimes that are so tragic. A student may come home to surprise her parents, comes into the house from a college weekend. They don't know what's happening. A father could kill a daughter. All these are horrible, tragic things that happen. But that doesn't make them criminally responsible, given those particular fact situations. We also talked about, and I think this is most important, the state's burden of proof. It's beyond a reasonable doubt. You as jurors have heard it when you grew up, I'm sure, in school, what beyond a reasonable doubt is. It is the highest burden under our law. You don't get a definition, but the court would tell you it's the highest burden under the law. And we talked about what is probable cause. It's arresting someone. When you sue someone for millions of dollars, it's preponderance of the evidence is the burden. When the state wants to take children from a parent's custody, it's clear and convincing evidence. But to convict someone of any criminal offense and murder, it's beyond a reasonable doubt. When self-defense is raised, when that evidence is raised, the state of Texas must prove to you beyond a reasonable doubt the defendant wasn't acting in self-defense. And if they can't do that, it's not guilty. Same thing on mistake of fact. If they can't prove the defendant wasn't operating under mistake of fact beyond a reasonable doubt, the instructions are clear, it's a not guilty. That is the law. And your oath in this case is to make your decision on the law and evidence. And it's clear. And here's what we're talking about, reasonable doubt. I put this up during jury selection. I want to remind you, just to illustrate how high that burden is. Low, obviously proven not guilty. Highly unlikely. If the evidence shows it's less than likely. Probably not. Unlikely. Possibly not. Clearly, that's not guilty. If the evidence shows it may not be, or perhaps that happened, or suspected the defendant committed murder. Possibly guilty. Probably guilty. Guilty likely. Guilty highly likely still doesn't reach that burden of beyond a reasonable doubt that you're required when considering these issues in this case. Don't forget that. It's a cornerstone of our Constitution that separates us from all of the countries in the world. And you've promised and taken an oath that you'll abide by that. When we talk about beyond a reasonable doubt, it's talking about it's a doubt based on reason, using logic. And what the state has to do, and that burden never shares it, is rule out every logical possible reasonable doubt. And they can't do that in this case. They can't do that in self-defense issues. They can't do that on the mistake of fact issues. I also asked you in jury selection to do this, and it's so hard, it's human nature to keep your mind open throughout the whole trial, to wait till all the evidence is in, and then review the court's charge, the law, and apply it to the case. It's very hard to do because in human nature, we want to start making decisions right away. We get angry, we get emotional when we hear evidence, and you want to start forming your opinions. But you have to use the discipline not to do that. And you all promised you could do that. The other thing you have to be careful of And there's an instruction on that in here, is that you don't, as the jurors in this case, decide this case on emotion and sympathy. That's hard, especially in a case like this. You'll never see a case like this that's so tragic. So tragic. It's hard to do as jurors. Who would not have sympathy for Botham John? Wonderful human being. Died in these horrible, tragic circumstances. Who would not have sympathy for his family? Or anyone in that position? Everyone does. But that is not part of your consideration as a jury. You can't say, I feel so horrible, I'm going to make something happen. That's hard to do. You have to calmly review the evidence without that emotion and follow your oaths. They don't want you to do that. Be angry and upset. Because that's what they need to do, because they can't get over this burden of proof beyond a reasonable doubt otherwise. They want you charged up. Now, I'll ask you to follow the law, because if we have jurors who are deciding things on emotion, then bad things can happen in criminal cases, and that's why the law is so clear. And you all promised that you could do that, and you could use that self-discipline. And we want you, we believe you. We want you to adhere to that promise. Here's the other thing. This case is different because there's been so much publicity. We had specific questions about it. Everyone's heard about it. It's been covered and covered and covered in the press, on social media. But all of you said, yes, if you heard about it, you put those things out of your mind and recognize the importance of deciding this case just on the evidence here in the courtroom. Because all that media coverage, everything you see on Facebook or any other social media, hasn't heard the actual evidence. You have. You're the only ones in the unique position to do that. The judges safeguarded this, made sure that jurors would be on the juror who had not formed opinions and could make these decisions. She sequestered you so you could avoid these pressures. And there is tremendous public pressure in a case like this. But I'll caution you, you as jurors have to ignore that, and that's very hard. Because people are upset about this case. It's emotionally charged. But if a jury starts making decisions because of public pressure, or, well, will they respond if I find this way? We can't get true justice in this country. Jurors must make their decision just based on the evidence and not how they think people want them to find. And I'll ask you to always have that in the forefront of your deliberations when you calmly and without emotion review this evidence. I want to talk about some other evidence. I had a slide up in jury selection about distraction. You need to concentrate on what the evidence is of what happened outside the apartment when Amber Guyger went in and what happened inside. What led up to it. Those are the circumstances. The circumstances viewed from Amber Guyger and the decisions she made. That's what's important, because we heard all kinds of evidence about things that happened after the shooting happened. All kinds of evidence. That's a distraction because it has nothing to do with the decisions were made in that apartment and just outside the apartment. Let me give you some examples. We heard about questions about should he use the walkie-talkie. She used a cell phone. Should have used a walkie-talkie. That's proper procedure. What does that have to do with beyond a reasonable doubt? Mistake of fact, reasonableness. What does that have to do? The incident happened. And when you look at the evidence, how quickly did an ambulance and officers get there? Within 2 minutes. Sergeant Valentine said she got there within 1 minute. What was the purpose of that? That's emotionally charging you up to get you angry. Oh, she didn't use her walkie-talkie. Is it their belief that Amber Guyger purposely wanted to slow down emergency personnel to get there? No. There was no undue delay, and it has nothing to do with what would happen in that apartment, but it's a distraction. No CPR. We either had evidence of she didn't do CPR at all, didn't have blood on her hands. I'll remind you, though, that the other officers that did CPR didn't have blood on their hands. Or she can discontinue doing CPR too soon, or didn't do it properly. Okay? All kinds of good questions about You didn't do CPR like the other officers when he was in his last moments of his life, and that's very emotional. Because yes, anyone laying there mortally wounded needs to be tended to. But what does that have to do with what happened in the apartment, or what you decide? Nothing. Nothing at all. It's designed to get you upset, to get you emotional. Amber Guyger said when she realized what was going on, she tried CPR with one hand. The operator, the 911 operator, wanted to know where she is. She doesn't know. She's realizing, come to the grip, she doesn't know where she is. She thought she had been in her apartment. She had to get up, go outside, and look. That's how confused she was at that point in time. And she told you, I did sternum rubs. Those weren't going to do him any good. But she wanted him to wake up. She'd seen paramedics do it. She was desperate. She wanted help to arrive. She left his side once to go outside because she'd been told by the 911 operator the officers were there. They're trying to find her. She wanted them to get help for him. She couldn't help him. And sadly, we now know from the medical examiner that bullet tore through his heart. CPR wasn't doing any good. Pressure on the wound wasn't doing any good because he had, the medical examiner called a rapidly fatal wound. He couldn't survive because of the wound he received, and CPR wasn't going to help. There's no one from Baylor Hospital that came in here and said, oh, if only CPR had been done continuously, he would survive. No, sadly, that's the hard truth. That's the hard truth. But we heard all kinds of evidence about it, questions, to get you emotionally charged up in your deliberations. We heard about texting, of course, horrible deed. About 3 minutes, 25 seconds into that 911 call, she sent 2 texts. Or one text, about a minute later, 45 seconds, another, to Martin Rivera. She's in absolute panic. I don't think anyone can doubt that when you listen to that 911 report. And she wants that one person, her partner, that she depends on there. She's just reaching out. Now, you can hate her for sending that text. You can. You can be angry with her. You can hate her, but you can't convict her because that's no evidence as to the decisions that were made in that apartment. It has nothing to do with it. But we heard all about it and took evidence because that, again, is designed to get you upset and angry. Because if you're angry at the defendant, it's much easier to convict them. But you have to look at this case coolly and calmly and decide if they've proven their case beyond a reasonable doubt. On this mistake of fact issue, on this apparent danger of what she was perceiving and going into that apartment thinking it was her own. It's a horrible, tragic event that happened from these mistakes and misperceptions that were made. The deleted text. You'll hear about that. Deleted text. Martin Rivera, yeah, I deleted text. Well, we all know why Martin Rivera deleted text. He's a married man. He had an affair. He was sending sexually explicit text messages and photos with Amber Guyger. He doesn't want his wife to find that out. Amber Guyger always deleted his messages until after this incident. Embarrassed, she said, also didn't want people to know, and she didn't want Martin Rivera to be in trouble. But does that have anything to do with what happened? No, not at all. Police procedures. All things about police procedures. And this is where they try to misconstrue what actually happened. Amber Guyger wasn't there to answer a police call, a burglary call. She wasn't called by a resident when she arrived and said, I think someone's breaking into an apartment, go there. They have procedures when they're called to those types of calls. That wasn't happening. She was just trying to go to her apartment. She wasn't there on a call. You heard Officer Blair when he talked about it. He said, yeah, sure, if I'm called to a burglary, I'm going to call for cover, get another officer if I'm called on a call like that. But if I'm going in my own home and I run into someone inside my home, I'm going to engage. I'm not going to retreat. I'm going to look for his hands. I'm going to face the situation. Amber Guyger wasn't there answering a burglary call. She didn't sit outside that apartment that heard rustling and said, well, it sounds like a burglar in my apartment. Should I call for cover or not? She explained to you exactly what happened. That decision happened in seconds and had nothing to do with any kind of burglary call. But we heard all about these procedures, of calling for canine units, backup. It has nothing to do with the facts of this case. And then we heard about Martin Rivera. The theory was, you heard that he was supposed to come over, and either Amber Guyger was so excited she made all these mistakes, or she was so disappointed. That's pure conjecture, but they used an email or a text from Martin where he said around 5:55 p.m., "When can I come over?" And we know from what they both testified to that they sent these texts to each other all the time, but there was no plan for him to come over. They both told you that. Martin Rivera went to a Boy Scout meeting. Then he went to the gym, and then he stopped to get something to eat. And it was his habit when he was out doing that, he would call Amber Guyger. And they told you that, yes, they'd had a sexual relationship, but that had ended either late 2017 or in early 2018. And Amber Guyger told you, and Martin Rivera told you, she'd lived in Southside Flats for 57 days, and he had not been over there. He didn't even know where she lived. How could he go over there? And we know they're telling the truth about that because this table, with their investigators, the Texas Rangers, their prosecutors, their technology, if they wanted to track Martin Rivera and prove that he lied, that he was always over at the Southside Flats, they could. They know what to do with cell phones, cell towers, videos, information from cars. But you didn't hear that because he's never been there, and he wasn't going there that night. Amber Guyger was just wanting to go home. Work out, take the next day off. Martin Rivera, he's going to work the next day. They weren't having a date. She wasn't distracted, but she made a series of horrible mistakes. What you have to look at in this case, and look at mistake of fact, because the evidence is clear on that, and the law. A person's conduct that would otherwise constitute a crime of murder or manslaughter is not a criminal offense if the person, through mistake, formed a reasonable belief about a matter of fact, and the mistaken belief negated the kind of culpability required for commission of the offense. The defendant is not required to prove that she made a mistake of fact. Rather, the state must prove beyond a reasonable doubt that the defendant did not make a mistake of fact constituting a defense. And the judge carefully lays that out. They can never overcome that burden in this case if you follow the law and the evidence. Reasonable belief means a belief by an ordinary prudent person would have held under the same circumstances as the defendant. And to decide the issue of mistake of fact, you must determine whether the state has proved beyond a reasonable doubt one of the following. The defendant did not believe she was entering her own apartment, or did not believe that the deceased was an intruder in her apartment. Or the defendant's belief that she was entering her own apartment, or her belief that the deceased was an intruder in her apartment was not reasonable. So let's talk about reasonable. We know from looking at the photos that that garage was not clearly marked. We know that from Detective Clark, who gathered all the evidence and she was putting the photos in. She didn't even know the difference between the third and fourth floor. She said that on the stand. I can't tell the difference. There were no large markers until after this shooting occurred on there. Just small little markers of where the fourth floor would be on the inside of that elevator. They look just alike. People make that mistake all the time. We know that. We know that their own witnesses, Josh Brown, has gone to the wrong hallway and gone to the wrong apartment and put a key into it. But they did something else, because obviously Ranger Armstrong gets on the case the next day and he knows, hey, we need to figure out if that's reasonable. People actually do this. And so what did they do? They brought a bunch of Texas Rangers out, they brought investigators, and they canvassed that entire complex because they wanted to know if this had happened to anyone else. And you'll get the statistics, and he testified to them. Could I have the next slide, please? I'm sorry, that's not it. when they questioned everyone, 93 people had said they'd gone to the wrong floor. And when they looked at it for the people that lived on the third and fourth floor, 46% of the tenants on the third and fourth floor had unintentionally parked on the wrong floor. 46%. Are those people unreasonable? When Amber Guyger is on the phone and parks on the wrong floor, what about all these other people? Nearly half, 44% of the tenants on the third and fourth floor said they unintentionally walked to the wrong apartment on the wrong floor. 44%, that's 92 people said they'd done the same thing Amber Guyger had done. So when you're considering whether it's a reasonable mistake, consider that. As Ranger Armstrong said, he thought it was a very significant fact. They're the ones that found this evidence. Their lead investigator and the other rangers, they found it. That's the evidence. What you consider, if this is reasonable mistake of what a person would do in this case. They can't hide from that fact. It's right there. They found it. What about their own witnesses? You know, we heard on opening statement, Mr. Hermes said Amber Guyger went past 16 apartments. She was on the wrong floor. She didn't see the roof line when she went across the bridge. She missed or didn't see mats that she should have been familiar with. She missed the big chromatic plant or whatever. Should have realized that. She made horrible mistakes. Yet it happens all the time. Whitney Hughes, a witness for them who lived across from Mr. Jean, said, yeah, I parked on the wrong garage twice. And I went with her down the hallways. I showed her, okay, there's a river rock mat. No, I missed that. She may have saw some other mats. Said, I'm not sure. As in regards to that plant, I saw that, but I thought maybe the neighbor put it out. People do that all the time. She went to her own, what she believed to be her own apartment. And her own apartment has a brown mat. This one doesn't, we can see in the video. And she put the key in. It wasn't until then that she looked up. Their own witnesses have made the same mistake. Josh Brown made that mistake. It happens all the time. We brought you other witnesses. Mr. Lipska, who went to the wrong floor and wrong apartment about a dozen times. He told you. He went once when he came out walking his dog and went in all the way in, saw a woman sitting on the couch and still didn't realize he was in the wrong apartment. We've heard evidence of doors not working properly, people not being able to find their friends there, the numbers being confused. They're up high, as Whitney Hughes said, up high, not on the door like you normally see. It's confusing, the very design. And now, finally, this evidence, the door being ajar, is so important when deciding the mistake of fact, the reasonableness of what Amber Guyger did. Because she told you, it's been her story, when she walked up to that door, the door was ajar. Now, this would be the view from the inside. The door was ajar. We know how the lock works. You have to put the key in if it's shut. If it's not your key, a red light will go off. You have to turn it if a green light comes on, and then you have to turn the handle. That didn't happen in this case because the door was ajar. And how do we know she's telling the truth about that? Because Ranger Armstrong went on September 8th to video the inside of Mr. John's apartment, and he closed the door behind him. And then when they were video in the room, they eventually came to this. Now, you didn't see it when the state played it, but we played the rest of it. And we came to this. They saw that the door hadn't shut because there's a problem with the strike plate. It doesn't shut. And it didn't shut on that day. And they videotaped it and had it documented. So all you have to do when you put the fob in is it makes the door open. Not only that, they came back in October. Ranger Armstrong came back with people from the district attorney's office. They said it was the same time of night, the same weather conditions, and what did they find? His door didn't shut often. It was in the same condition Amber Guyger said that's how it was. All right? She's not lying about that. She's not lying at all. That's what happened in this case. It's one of the series of horrible circumstances that aligned together that resulted in this tragedy. All these other people have gone to the wrong apartment, put keys in. And that's what happened with Amber Guyger. She walked down that hallway just like all the others did, except she had something else different. She had about 30 pounds of equipment hanging on her left arm. She had this, walking on her left hand. Just wanted to go home, just calm, like the others, just like Whitney Hughes wanted to go home. And she didn't notice these things. And she comes up, and there's, you've seen in some of the photos, a pillar that sticks out as you're coming up. She knows her apartment because she doesn't look for the numbers, just like everyone else doesn't. They can sense where they are, and she knows that where that balcony is, that's where her apartment's going to be, 1378. And she comes up, she's getting her keys. She's coming up here to where this red mat would be. But she's got this. And it could easily obscure what she's doing, and she's not looking at the ground. And we know that 43 inches is how high it is, and she's 5'3" maybe. So she's not looking down here to put it in, it's here, right about here. And she's not thinking anything in particular at all, just has her equipment. And she described to you what happened. And it takes a long time, and they want you to think it happened a long time, but it didn't. It happens in seconds. And she told you how she went from complete calm to complete panic. And you've all experienced in your life, thank God not in this kind of situation. Ranger Armstrong said, yes, it can happen. You get the tunnel vision. Your heart suddenly kicks in. Blood is rushing because suddenly you feel in danger. You may have experienced that when you're driving down the highway and you wander another lane, or someone wanders in your lane, or some child runs out in front of you. You have to slam on the brakes. Calm 1 minute, you have to react. You have to avoid a collision. You have to avoid a child. And if you do so, what do you hear? That heart beating, sweat. It happens in a nanosecond, and that's what happened. And Amber Guyger explained to you what happened. She walks up. She doesn't wait outside or anything. She's putting the fob in. It's going in. Right at that second, she sees the door that's ajar. The very motion of that pulls the door open. And the very same time, she hears rustling around. All those things come together. Her test tightens up, and she says, my God, someone's in my apartment. Because she left it locked. Someone's in my apartment. And that door's opening up. She doesn't wait around at that point and decide to charge in. It's opening up all in one motion. This is all happening in 1 second or two. And she pulls that door open, and the lights are off. And she's face to face there at the end of the apartment with a figure. And her heart is beating, and she is scared. It's a reasonable mistake anyone could make. And her gun is pulled out, and she points it at the figure. And she tells you what she said. Training kicks in this. Let me see your hands. Let me see your hands. But he's moving around. That frightens her. He doesn't comply. In fact, he comes forward. He's walking. And he's saying, hey, hey, hey. All she's thinking in her mind is, ignore my gun. He must have something. He's coming to harm me. And she has to make that split-second decision. And this time it ended in tragedy.
Give you 31 minutes.
Thank you, Judge. And he fell. She didn't make a decision, I'm going to charge in there and start shooting people on the stage. He fell. And the physical evidence shows that she's telling the truth, because Ranger Adcock said, yeah, the casing's there. They're in the kitchen area. When we do our laser from where she says she was, that matches up to the second shot, probably, because of the recoil with one hand. And yes, this area, about 13 to 15 feet out front in that line, is about where he fell. And then she comes to the horrible realization when she came around that counter that she was in the wrong place and made a horrible, horrible mistake. That's what they have to prove beyond a reasonable doubt, that she didn't make a reasonable state of fact, or she didn't believe that was intruder, or that she didn't exercise the apparent danger of believing there was a threat. They have the burden of proof to prove that beyond a reasonable doubt. What do they do that with? Josh Brown, nice kid. He was their ear witness that was out in the hallway. He was about to come around the corner. What did he hear? He said he heard two distinct voices. He didn't know if they're man, woman, but two different voices, like talking at the same time. He can't understand what they're saying, but it was like they were like surprised with one another, like they came in on one another. That's the tone, and that's important. Like they're surprised at meeting one another. That's the tone he heard. He couldn't understand what they were saying. And they get him to say, well, you didn't hear any commands. Well, he can't understand what they're saying. He doesn't know what Amber Guyger is saying. Okay? But the tone's important, because what does it do? It matches exactly what Amber Guyger says. She's saying, let me see your hands, let me see your hands. Both saying, hey, hey, hey. Josh Brown corroborates Amber Guyger's story. He didn't go to proving beyond a reasonable doubt that she wasn't acting reasonably under mistaken fact, or beyond reasonable doubt that she wasn't exercising self-defense in what she mistakenly believed at that time. He corroborates exactly what went on. Then we have Miss Kinsey, who lived next door. She said, you know, I've only heard people over in Bo's apartment one time. That's when he was watching the NBA Finals, and his back door was open and my back door was open. Otherwise, I can't hear in his apartment. And she's talking on the phone, and she hears something. She thinks are shots. And then she says, I heard a man and woman kind of yelling. And then she remembers Amber Guyger out talking about giving out the number where she was. Could she have been mistaken? Which Josh Brown says the conversation happened before, right before the shot. She says right after. Doesn't mean both are lying or either one of them's lying. Could she be mistaken? Yes. Then you had Miss Hughes, who lived across the hall. She didn't hear anything beforehand, but she told you, no, I can't hear my neighbors in their apartments. She was watching TV doing her nails, and she heard two loud bangs. She doesn't help them prove their case beyond a reasonable doubt. Because self-defense has been raised, mistake of fact has been raised, and they have the burden to prove it. But they can't do it with those witnesses. The 911 call. Amber Guyger's on 911 in a panic. Prosecution wants you to believe that's some kind of interrogation, and because she didn't give those specific facts, somehow that means she wasn't in fear of her life, because she didn't say I was shooting in self-defense. She's in absolute panic. She's not being interrogated and giving a statement. You can't rely on that at all. And finally, there's the bullet angle. They have said in their opening, and they keep saying, that Botham Jean was on the couch. Yet there's no evidence of that. I talked to the medical examiner about this. We could have the next slide. Amber Guyger said he was coming forward, and it was fired. And the medical examiner said, look, I said, is this possible? Because we have our angle, all right? If someone is coming forward and they see a weapon, is it possible they could duck? I said, yeah. Bodies are fluid. People, when they're frightened, move quickly. Someone's going to shoot at someone, they're going to try to avoid it. And that's how you get this angle. He says, all I can tell you is that's the trajectory of the bullet. How they were positioned could happen many different ways. But yes, he said, yes, that could very easily be the situation. So when he's coming forward, that's what you see. And it's so sad, really. It's so sad because obviously he had set the food down. Go to the next slide, please. Next one, please. Next one, please. You can see the bowl, but the spoon is pointed away. You can see the computer. He just set the bowl down. The lights are off. When he went home, he didn't know his door had left ajar, obviously. He didn't know that. He has ear pods in his ears. He can't hear. He's paused that TV. We know that. He paused it. He wasn't watching TV, probably to go fix his ice cream. And then he set it back down. He hadn't had a chance to unpause it. And then that door opens. And all he can see is a figure coming in. And why isn't he? Of course, he wants to know who's there. So he is saying, hey, hey, hey. And these two people have come into this situation, this tragic, tragic situation, and it's resulting in this horrible tragedy. It's like a horrible, perfect storm has come together, and this happened. Then we have the state's version of what may happen. They say, well, he was on the couch. There's no physical evidence showing he's on the couch. Yes, the bowl of ice cream is there. And if I could have the next slide, please. There it is. Look how the spoon is. It's not as if you're eating. We saw another photo of it's piled up. It's just been placed there. The cookies are still there. There's his computer, the TV. It's the game center. It's all on pause. Everything's on pause. And I said, okay, what would the angle be if he were sitting on the couch? Well, first of all, we went over painstakingly that if a person's going to get up off the couch, they may do it like this, depending on their physical, how they're built, how comfortable they are. Or, yes, you could have it. But if you're going to be shot in this position, you're going to be leaning over like this. Okay? That's how it would have to happen, as if you were getting up. Okay, if you're getting shot in the heart, pierce your stomach, your lungs, is it reasonable to expect you might fall backwards on the couch at that point when you're hit by that round? There's no blood on that couch at all. We know that. The police looked. The DA's office was out there. No one saw blood. Is it reasonable, using your logic, that if you're in this position and you're getting up, leaning forward, and you're shot in the heart, you might fall forward, and if you fall forward, you're going to hit that computer, that ice cream, all those items. He's a 247-pound man, 6'1". That ottoman's right there at his knees. How did he avoid hitting that if he's shot in the heart getting up off the couch? And then, under their theory, he has to get up and walk about 7 feet towards the person that just shot him, then fall backwards. And we know where he hit because his ear pods popped out of his ears. And the only blood is right there. What's more reasonable? The Ranger Adcock said yes, he's about 13, 15 feet away, and he fell backwards after he shot. And I want you to take special notice of this, because I know you're going to look at it. You see that little brown or reddish mark? I don't know if they're going to argue that's blood showing Botham gene coming across, but we know it couldn't be. I asked the paramedic, Farley, hey, when y'all came in there and exchanged the body, there was a body, put it on the stretcher, there was a lot of stuff going on. Could blood get transferred, get it flung about? Yeah. Next slide, please. No, the other way. We introduced this into evidence. That's from Officer Gwynn's body camera. Botham John is on the ground. He's being tended to by all these officers. But look, that area where you saw the red spot, nothing's there. The flashlight caught it. Nothing's there. So whatever was placed there later happened after he was shot and on the ground. Most likely when he was transferred up. But nothing's there. There's no physical evidence that puts him on the couch. And their scenario makes no sense. This is a sad, sad, sad case. We'll ask you to follow the law and the evidence. It's one of those cases that no one would ever think would exist. And it's one of those cases where there are no winners. A wonderful human being has lost his life, but the evidence shows it's just a tragedy, a horrible, horrible tragedy. Thank you.
You have 19 minutes.
May it please the court, members of the jury, defense, Amber, why are we here? The state will have you believe this is an out of control, unreasonable police officer that went on a murderous rage for no reason. That's what they're trying to show you. Why are we here? We're here because an awful tragedy occurred. An innocent young man lost his life. And a mistake was made that caused that. But what you are to consider is what the law is. And what they have to disprove beyond all reasonable doubt is whether the decisions that she made in entering that apartment and believing that it was her apartment and believing he was an intruder were so unreasonable. You must determine whether the state has proved beyond a reasonable doubt one of the following: the defendant's belief that she was entering her own apartment or her belief that the deceased was an intruder in her apartment was not reasonable. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or element 2 listed above, you must find the defendant not guilty. That is the law. They don't like it. They are distancing themselves from the law. I think Mr. Fine called it garbage or trash or something like that. We're not here because whether they like the law or not. We're here because you are bound by the law. You are individuals that have sworn an oath that you are going to base your verdict solely on the law and the evidence. And the state has failed to prove anything. The state has failed to do their duty. We actually, even though we have no duty, we showed you how this was a reasonable mistake. The state, what did they bring you? Sexting and speculation. Everything that they have done has been to try to distract you and trick you from looking at the law in this case, because they know that if you apply it correctly, that Amber Guyger is not guilty. Sexting and speculation. But what it's about is Amber Guyger and how we got here. And is she an unreasonable person? Was it unreasonable for her to dream of being a police officer? Was it unreasonable for her to work full-time and go to college so she could put herself in that position? Was it unreasonable for her to join the Dallas Police Department and go through the academy and receive the training that teaches you how to use deadly force, to receive the training that teaches you that suspects' hands kill, that burglaries are inherently dangerous, and when you encounter a burglar, you go to your weapon? They had the opportunity to bring anybody from the academy to say that she acted counter to her training. Again, it's their burden. They have to prove that. They did not prove that. They brought you some standing operator procedures that we know do not apply. Because this was not a dispatch burglary call. This was not a barricaded person. This was not the situation where you have time to plan. Amber Guyger spent her life trying to do the right thing. She joined the South. She was moved to Southeast Patrol. She joined the CRT team. She interviewed and joined a team that has to be ready at any moment to respond to the needs of the different investigative units to help them detain and arrest the murderers and rapists and the robbers. Was that unreasonable on her part? Was it unreasonable for her to work hard? You have her work records that show in August there were several times she went to work at 5 in the morning. There's some days she worked 14 hours. Some days she's got lucky and only had to work 8 hours. And those are hours where your alert level goes up and down, as we saw on September 6th when she woke up at 5:30. When she got to work at around 7:45 and immediately started looking at intelligence reports because she wants to know what crime is afoot in her area, where the hot spots are. And she has to focus and pay attention, because if you don't understand where the violent criminals are, it could cost you your life. And so September 6th is a day full of ups and downs as far as alertness. They patrol regularly, looking at the different hotspots in the morning. Then they go to Central, and they have to have a debriefing with the SWAT team. And if you don't pay attention to that, because they're going after some armed and dangerous felons, if you don't pay attention, if you're not have a clear understanding what everybody's role is, then a mistake can be made and you could lose your life. So there's all these different levels of alertness. They go to the scene, they're on the perimeter, they are watching SWAT's back. They are protecting SWAT so SWAT can get these dangerous violent felons. Then they transport a dangerous violent felon to headquarters. And then they have some downtime. But they're still responsible for these dangerous violent felons, so they don't go all the way to zero. You know, when you're at a 7 or 8, when you're out on the perimeter, maybe you're down around a 4 or 5, but you're still aware, you're still working. They make it sound like the police headquarters is a day at the spa. No, they're abiding by their duties and their responsibilities. And then they have to take the same dangerous violent suspect to jail and get him booked in properly in jail without any incidents. And then she goes back to the Southeast substation and docks her body camera, and she goes to zero. Keenan Blair told you, when you clock out, it's a different mindset. All that day of going up and down on alertness and everything else, she goes to zero. It's over. And she gets on the phone with Martin Rivera, and there is zero evidence. They brought you zero evidence that that was anything other than a phone call. Martin Rivera got up here and told you what it was. He admitted to all the sexting. He admitted to the prior improper sexual relationship. So why would he have to lie about the contents of that phone call? They want to speculate. They want to anger you at these people that are having this improper relationship. But there is zero evidence that phone conversation was anything different than the other phone conversations that they've had. And she gets to her apartment, and she backs into, she got lucky. And she went up in the parking garage, and she backed into that parking spot. And she saw the entrance. And she grabbed her 30-plus pounds of gear, and she walked straight in. And she didn't notice the skyline. Is that unreasonable? Is that criminal? Is that evil? Is that evidence of a murderous rage? And she walked down the hallway. So she had parked on the wrong floor, like nearly half the residents on the 3rd and 4th floor have done. And she continued down the hallway towards the wrong apartment, like nearly half the residents on the 3rd and 4th floor have done. And she got to the door, and she put her key in, like 1 out of 4 residents on the 3rd and 4th floor have done. And everything started to happen in one motion. She heard the shuffling. She's putting the key in, and we know the key was the door was ajar. You heard from Special Agents Estes and Wallace about other people that they had interviewed where the door did the same thing. You heard from Texas Ranger Armstrong and saw the photos of the strike plate. You heard about the experiment that they did where the door did not shut all the way. You saw the video that shows the door is not shut all the way. Was that an unreasonable, evil circumstance created by Amber Guyger? The fact that there's no clear visual indicators on the parking garage walls, the fact that there's no numbers at eye level as you walk down these hallways of this apartment, the fact that there's no different color coding for each floor, is that Amber Guyger's unreasonable, evil action? And she gets to that door, and she obviously doesn't notice the red floor mat. Because what purpose? Why would she look at the red floor mat and say, you know what? I don't like this red floor mat. I'm going to go in and kill whoever's in here. Obviously, she didn't notice the red floor mat. And she put her key in, and it's all in one motion, and it pushes open. And my God, she's hearing these things, and she knows it's her apartment. She knows it's her apartment. And she goes from 0 up to 10 in a millisecond. Her heart rate starts to rapidly increase. Her heart rate starts to elevate. She starts to get that tunnel vision. And she's going to focus on what she perceives is an intruder. because everything else doesn't matter. She knows she's in her apartment. The lights are off. All we have is the glow of the TV and the computer monitor. She doesn't have the benefit, like Mr. Hermes, of going through the photos with Robin Carr and pointing out every little distinct difference when all the lights in the apartment are on and she's using flash photography in those photos. Hey, look, he has a photo and she doesn't. She has a photo and he doesn't. Is that evidence she was unreasonable? That is ridiculous and absurd that they went through that. We went through hundreds of photos pointing out these differences that she obviously didn't see. She's focusing on an intruder in her apartment, and then the training kicks in, and she draws her weapon because she's taught that burglars are dangerous. And it's too late now. She's face to face. Keenan Blair told you. It's different. It's not a burglary call if you walk into your own home and are confronted with an intruder. It's different. You address the threat. Michael Lee told you it's different. You address the threat. Keenan, what do you focus on? Hands. Why? Hands kill. And it's dark in there and she can't make out the hands. And poor Mr. John, he's got his AirPods in. He's smoked marijuana because we know it's in his system, and that's not relevant for any other reason than it might have added to the possible confusion and his ability to process this. He's not to blame for that. No one is. But he's trying to process this, and you look at those photos. They make it sound like he was sitting on the couch eating ice cream. The spoon is pointed away from the couch. When you're starting to eat a bowl of ice cream, the spoon is within where you're going to eat it. It shows, the physical evidence shows, he probably set down the ice cream, and Amber Guyger comes into his apartment, and he's trying to process it. And all these circumstances have happened, and none of them are because she's unreasonable. None of them are because she's evil. It's because it's this storm that has come together, the perfect storm, and we know when she's standing in that apartment. She's done all these things all her life that she is reasonable. She's an ordinary and prudent person who made a mistake. She's an ordinary and prudent person who believed that this man who she's drawn a gun on, who keeps coming at her, who's saying, hey, 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 as she's saying hands, let me see your hands, as Josh Brown corroborates, she believes this intruder is coming to kill her because he got caught and he's way back in the apartment and he's coming for her. And she fires her weapon. She fires it twice in quick, rapid succession like she's taught. And to that point, she's done everything like she's been trained to do and taught to do, and then she realizes what had happened. Now, the physical evidence is important because they have concocted a narrative that has zero support in the physical evidence. And that is so crucial. Because when you look at the evidence, when you look at Michael Lee's body cam, and you go to 5 minutes and 26 seconds in, you see the feet position of Mr. Jean. You see right there, that's, no one's moved the body. They tried to make it sound like the body was being moved. The body was lifted up. The feet were lifted up, but this is before the feet were lifted up. You see Mr. John's feet. They're lined up with the frame of the bedroom. You see his right foot right next to a flip-flop and his left foot a little further out. So his body is facing the doorway. And so it's reasonable from the evidence and what Amber Guyger told you is that he's coming forward, and he's facing the doorway because the shot is straight on. The shot doesn't deviate either way. He's coming towards that doorway. Hey, who's in my apartment? And he sees the gun. The last thing she saw is this figure that's upright coming at her, and he gets shot. And that's consistent with the angle. And that's consistent with him falling right here because he had a rapidly fatal wound. It is pure conjecture, it is pure speculation to try and say that he would have taken 2 purposeful steps. That is out of the imagination of the state of Texas.
You have 3 minutes remaining.
Thank you, Judge. You have the AirPods that you can see are just lying right next to Mr. John's ear. I find it hard to believe and hard to fathom if he was somehow getting up off the couch that he would have perfectly navigated the ottoman, walked towards the person that just shot him. So for some reason, he's been shot. He's walking perfectly in a straight line towards the person that just shot him. The AirPods are still in his ears and somehow stops and falls back. That is preposterous. That is the conjecture that the judge has told you not to engage in. The investigation by the Texas Rangers. So the Texas Rangers come in. The Texas Rangers, one of the most elite investigative units in the country. And Ranger Armstrong told you what he did. Because he wanted to know, his focal point was her coming to that apartment reasonable? And every step he took of the investigation and everything he did showed that it was. The canvas, was that significant, Ranger Armstrong? Oh yes, it was significant. The door, well yes, it does. It corroborates Amber once again. The parking garages, the layout of the apartment complex. The physical evidence corroborates what Amber Guyger told you. The state of Texas cannot bring you one shred of evidence, anything that shows that she was unreasonable. The state of Texas cannot bring you one shred of evidence to support their absurd hypothesis about him sitting on the couch. Ladies and gentlemen, thank you. Thank you for your time. Thank you for letting us take you away from your families. This case is a case that depends upon you to look at the law and look in the evidence. And it's clear. If you find the state has failed to prove that she was unreasonable, if you find the state has failed to prove that she was unreasonable in her belief that Mr. John was in her apartment and that he was an intruder, you must find Amber Guyger not guilty. Every single one of you has the power to say not guilty. If the state did not prove this case beyond a reasonable doubt, if a single reasonable doubt remains, each and every one of you has the right and the responsibility and the duty and the courage to say not guilty. Ladies and gentlemen of the jury, the evidence is clear. We've proved it. They certainly have failed to disprove it. That Amber Guyger firmly believed, reasonably, that she was in her own apartment. That Amber Guyger firmly believed in those seconds that she was facing an intruder. The law is clear. Your duty is clear. Find Amber Guyger not guilty. Thank you.
Mr. Hermes, I've given you an additional minute, so you have 27 minutes.
May it please the court. I think really, and I'm going to get into the legal issues in this particular case, the factual issues in this particular case, but I think where Mr. Rogers just left off and where I'm about to begin really does underscore the difference of opinion. Because the state of Texas does absolutely find it unreasonable that a trained 5-year veteran of the Dallas Police Department could go into the wrong apartment and shoot an unarmed man who was doing absolutely nothing wrong in the chest. The state of Texas finds it absolutely unreasonable that a person could do something like that and just say, whoops, my bad, and then go on about her life however she chooses to do it. Yes, the state of Texas finds that premise to be unreasonable. In fact, we find that premise to be unjust and unacceptable and insulting. A 5-year trained police officer who, as a matter of her ability to perform her job effectively, is trained to observe and to orient and to maintain situational awareness. We're not talking about somebody who just walks around, every day doing whatever else. She was given a special job at the Dallas Police Department, a position, because her observation skills, her awareness skills were that good. That is not where you put the slackers or the sleepers. So yes, to accept the premise that she could just walk into somebody's home who was no threat to anybody, kill that person, and then walk away with, geez, I really messed up there, is absolutely unreasonable. And it's unacceptable on a human level. Now let me just talk to you about where we are legally in this case. The facts that are undisputed right now are that on September the 6th, 2018, here in our community of Dallas County, Texas, this defendant shot with her firearm Botham John, killing him. And by her own admission on the 911 call and in this courtroom, it was her intent at the moment she shot to kill him. Those are the elements of murder, proven beyond a reasonable doubt. And those elements and those facts are not in dispute. So that's a starting spot. This defendant has committed murder. All right? To that charge, she and her team asks for you to give her the justification of self-defense. She has claimed that she was acting in self-defense at the time that she shot Mr. Jean. And Mr. Fine did a fine job going over all of the requirements that a person has to have in order to have the benefit of self-defense. Because I'm here to tell you, as a state's attorney, there are times when you have to use self-defense righteously and reasonably to save your life. And that's fine. That's why it's there. This is not one of those cases. And I'm just going to, and Mr. Fine put all of the elements up there for you. I'm just going to talk to you about two. Because she would have to have all of them in order to benefit from that justification. I'm going to show you where she fails on the two most important. First, and understand the premise of where these are coming from, because you have to kind of understand the background to appreciate why these words need to be given the meaning that they deserve. The premise is the sanctity of life is paramount. Life matters. If there's a reasonable alternative to taking somebody's life, then you are not going to benefit from the defense of self-defense, ever. And rightfully so. That is an option that the legislature has given us as a last resort when there are no other options. And why would it be any less? Why would we want to kill another human being when we could have done anything else? Right? So let's just talk about a couple of things that are required. Number one, in order for this defendant to benefit from self-defense, her decision to use deadly force must have been immediately necessary. And those are the words, ladies and gentlemen, that I need you to hear and give those words effect. When the legislature said immediately necessary, when we in our community have adopted this, those words mean something. Immediately means now, this second, at this moment. God bless you. That's what immediately means. It doesn't mean in a few seconds or in a few minutes or if this should happen or if that should happen. It means right here, right now, I have to act. Nothing less. Necessary. Necessary means that you have to do it. There's no other choice. If you have a couple of different options that you could reasonably do, then killing somebody is not necessary. And unless you have the confluence of those two doctrines where it is immediate and necessary, you do not get to kill somebody and say, whoops, too bad, I'm going on with my life. So let's just talk about this concept first. What are the actual facts of this particular case when it comes to her decision to use deadly force and whether that was immediately necessary? We've long suspected her decision to use deadly force was made in the hallway. We've long suspected that because the keys were left inside the lock, which were indicative of her pulling her gun. She needed that right hand, and obviously if she had a free right hand and she really believed this was her apartment, she would have taken out her keys as she was going in. Well, the trial confirmed that. Because not only on her direct examination, but on cross-examination, I made it very clear to go over this with her 2 or 3 times. She was in a position of safety behind a steel door in the hallway when she says that she made the connection between the fact that her door wasn't locked, it was ajar, and that she heard somebody on the inside. She was outside the door. She knew there was someone inside what she thought was an intruder. In fact, it was actually Mr. Jean doing absolutely nothing wrong. But she had the advantage of knowing someone was inside, and she assumed it was an intruder, and she decided from outside, from that position of safety, that she was going to engage what she calls the threat, and she decides how she's going to do it is by pulling her gun, opening that door, and going in to engage him. Now, what does that mean? That means she had options. That means deadly force wasn't immediately necessary. By her own admission, she didn't have to even retreat. She could have just stayed in the position that she was if she wanted to. Mr. Shook brings up this thing about the radio, about how we're trying to talk about after the fact. No. I'm talking about right then and there. She had a police radio on her. She had her cell phone on her. From that position where she was safe, outside that door, she could have called for police and said, I have an intruder, apartment 1478, or whatever apartment she wanted to get. She could have called for anybody to have come. They could have treated that like a barricaded person. They could have contained it. They could have used loudspeakers. Probably Mr. Jean would be alive had she decided to take the less lethal option. But she didn't. Because in her mind, at that moment in time, she decided to go in and engage that intruder. Now let me illustrate one other point that I think is critically important. By its very nature, self-defense means you're acting defensively, right? Does that make sense? What does it sound like she's doing? She is in a position where she is safe and secure, where she has options that she could have called for help. But what does she decide to do instead? Staying out there, calling for backup, calling for help, maybe even taking a different position of additional safety was an option that she had that she decided not to do. She didn't decide to do any of those defensive things. She became the aggressor. That's not self-defense. She decides from outside that door, I'm going in, I'm advancing, I'm engaging, and I'm going to deal with that person inside. And she's already indicated how she's decided to deal with them. She has a whole belt full of tools. She chooses to go after the gun, which is the most deadly weapon that there exists out there. And she tells you that she's going to engage. And what she does as soon as that door is open, and Mr. Shook, I'm just going to beg you differ. My recollection of the testimony was that she put the key in the door and it opened up slightly. And I stood there at that gate the other day and I indicated every single time, pushed it open a little bit, pushed it open a little bit. And I said, was it then that you heard this person inside? Yes. Then she indicated with the left arm she opened up the door fully and that she used the left arm to keep that door open. That she used her gear to help keep that door open. She must have done that because that room until she saw Mr. Jean. The light from the hallways have these bright lights, floods into the room, and she's scanning the room. And Mr. Jean, unfortunately for him, he made it easy. You know, not only is he getting up from his seated position, but he's also saying, hey, hey, and these are normal reactions. He's pointed himself out immediately to her. And as soon as she acquires him, she shoots. How do we know that? You heard the testimony of John outside his home, and he knew there was an intruder inside. He wouldn't go in. He would respect the sanctity of life. He would call for backup. He would have taken a position of cover and concealment. That's another police officer, another person who is trained like her, who would have been using common sense and reason and appreciating the value of life. For Amber Guyger, Mr. Jean was dead before that door ever opened. And that's just the simple truth. I want to talk to you about also a little bit about her departure from training. Mr. Rogers wants to say that you really can't factor in what her training requirements are because this wasn't a dispatched call. Repeatedly, Amber Guyger testified that she would resort to her training in her everyday life. She was off duty when she backed her truck in, but police officers do that because they want to be able to get out quickly. She resorts to her training in her common everyday life. She talks about how she keeps her right hand free in case she needs to draw for her weapon. She was off duty when she did that. Why then would she abandon training and orders that she has had that is read it. Standard Operating Procedure 1509, I think. 15 or 1709. It says 4 different times. One time in all capital letters. Do not go in. Call for backup. Take a position of cover and concealment. This is for your safety and their safety. Only go in when the scene has been contained and backup has arrived. You know, you can't have it both ways. You can't say, I'm going to take advantage of my police training sometimes and not others. Keenan Blair would have taken advantage of his training and he wouldn't have gone in. Because I think that's also indicative of where Amber Guyger's mindset was about that Botham was going to die. She didn't give loud commands. There were 5 to 10 witnesses that live within earshot of this particular apartment. All of these individuals indicate that from the hallway you can hear when people are speaking and moving. Not one single person ever heard her say, show me your hands. Not once, let alone twice. And they talk about the power of the state to bring anybody down that we want. They have the exact same power. There were 300 people at that apartment complex who were interviewed that had some, all, or no information to share. If there was any single person that heard, let me see your hands, they would have been in here. Not one person heard that because she didn't say it. Because again, the truth was she made the decision to kill from outside that door. And once she put into play, she executed that plan perfectly by entering that door and shooting Mr. Jean. Let me talk to you about the other aspect of self-defense that I think clearly evidence shows that she woefully fails. And that is that in order for you to be allowed to use self-defense or deadly force to kill somebody else, it has to be in response. It has to be for you protecting yourself against another person's use of deadly force against you. All right? It's not just a matter of that it's immediately necessary, but also it has to be to protect you from deadly force being projected on you. And I still, as I stand here right now, I wonder what the defense is suggesting Botham Jean did that constituted deadly force on Amber Guyger, that would have allowed her to use the justification of self-defense. There is no question, it is undisputed, he was unarmed. That man had no pockets. There was no place he could have even hidden something. That wasn't his way anyway. There's absolutely no dispute that she saw a weapon or saw something that she thought was a weapon. I mean, how many times have we heard from police, oh, he pulled his cell phone out and I thought it was a gun or something. There was none of that. All Mr. Jean did was get up from a seated position to see what the person was coming in. The only other reasonable alternative was him cowering down behind that wall that separates him from Amber Guyger. Getting up from a seated position or cowering down to avoid getting shot, there is no way that any reasonable person can interpret that kind of body position as being deadly force. There's just not. And if the defense wants to somehow suggest that him being bent over at an exceptionally deep angle, like this it would have to be, what was he going to do? He had an ironing board in front of him. In front of that, there was a 3-foot kitchen counter in between him and Amber Guyger. What was he going to be doing, leaping over like some sort of a ninja? There is absolutely nothing that Botham Jean did or that she could have even reasonably perceived that projected deadly force on her, against her, having failed both of the most important parts of self-defense. She doesn't get it. She doesn't get it. And I understand, I'm going to actually agree with Mr. Rogers about something, about the effect of sympathy. Because, see, one of my concerns is that facts like that really matter, the fact that both of them couldn't have been any kind of a threat to her at all, I'm scared that you guys might just decide that that doesn't matter to you. Because, see, you got to be in a courtroom and look at her for 7 days. She got to get up here and talk to you. You know? Because of what she did, this is all I can bring in. Mr. Jean can't come into this courtroom and appeal to your sympathy or to your emotion. He's been reduced to a cardboard photograph. So I implore you, please, please use your common sense in how you interpret this law. Self-defense is an option of last resort. She killed him unreasonably and unjustifiably. And just because she wants to throw out that I did it in self-defense, I need y'all to critically apply the facts that you heard in this case before you give her that. Because again, the state of Texas proudly takes a position. This is not one of those things where you could just say, whoops, too bad for you, buddy, you're buried 6 feet under, I'm going on about my life. No. If they thought that I was ashamed of that position, I've never been more proud of a position I've ever taken. Killing this man was unnecessary and it was unreasonable. It was unreasonable from start to finish. She had options outside that door when she had no danger. Options that didn't involve any violence to anybody. She didn't want to use it because she wanted to engage him. And everything after that was just a mere formality. We have proven the offense of murder. We have proven that the justification of self-defense doesn't apply on at least 2 grounds, any one of which requires it to fail for her. Amber Guyger is guilty of murder, and the state is entitled to that verdict, because that is the just verdict. And it is unacceptable that there could be no consequence for all of her unreasonable acts and her unreasonable decisions that she made at that time. Now, the defense points out that in the charge, you have been given the reasonable mistake of fact. And Mr. Fine was very careful and he was very clear on how that applies as well. It is a reasonable belief standard. And thank you, Your Honor. And that reasonable belief standard is based upon not only what an ordinary and prudent person would do, but from her circumstances as a trained police officer. And it was unreasonable. Listen to just this partial list of everything to do with where she was. Okay, she missed the roof line. She missed the floor number placards that are on the elevator. She missed 16 or 17 apartment numbers going to her door. She missed decorative flower pots and different kinds of floor mats on the floor. Most importantly, and this is the one that just can't be overcome, there was no other floor mat like this in the entire building. This thing sticks out literally like a red thumb. You can't miss this. When I carry this around the room, in this gray room, kind of like the gray floor at that apartment complex, you can't miss this. And she walked up to it and stood on top of it. Now, maybe Guyger didn't allow that to process in, but that's not the standard. It's whether an ordinary, prudent person with that kind of training and observation skills, no reasonable person would have missed this. That's not all, though. She missed the smells, the different smells about the room and the hallway. She missed all the furniture. Look inside those apartments. Look inside. They're not furnished anything alike. And from her vantage point, she could see entirely in. She missed the artwork on the wall. She sticks her key in, and as it's going open, she saw that red light blinking. And she knows that means that the lock doesn't recognize the key. She recognized the door wasn't locked when she knew that she locked her own door. All of these things would have put a reasonable person, like Miss Rose, who testified, would have put a reasonable person on notice to take a second. Take just 1 second and think about what is going on and what everything is telling you that this is not right. And she just refused to do that. She didn't even consider the fact that maintenance would be inside. I mean, she was on notice that maintenance was coming by that particular week. Now, I understand it was late, but anybody who's lived in an apartment knows that that's a possibility. It may be a remote possibility, but you may have somebody from maintenance in your room with a burst pipe, a small fire. You just can't walk into an apartment and start shooting, especially when you know that there might be somebody, like from the apartment complex, that's inside there. And let's talk about the reasonableness again. As Jason said, what kind of burglar goes in, sits on a couch, and is watching television? Now, let me just move on to that because, and also don't forget, there's actually no signs of forced entry. And that goes to the Castle Doctrine. In this particular charge, yes, she's asking for the benefit of the law that protected Botham Johns. And that's just wrong, but it's there, and y'all get to consider it. But in that, there has to be forced entry of an occupied residence. That doesn't exist. There has to be evidence that he was trying to push her out. That doesn't exist. Or there has to be evidence that he was trying to kill her, rape her, or somehow assault her or rob her. None of that exists. None of that exists. And they question, how is it that we're so confident that Amber Guyger walked in and Botham John was sitting on the couch? It's because it is the only explanation that fully comports with the 3 sets of physical evidence that existed on the scene. Number 1, the trajectory for the bullet that hit the wall. Number 2, the scene context of what's going on right in that immediate area, as far as the ice cream and such. And number 3, the wound path that the medical examiner testified to. This is number 1. This is the trajectory of the bullet that hit the wall. Look where it goes. It goes right in front of that center cushion of the couch. It goes right over the seats of this couch. This is the trajectory that both bullets were following, because you know that they were rapid shots. There wasn't time for a quick movement. Number two, the scene context. The physical evidence from the scene context. They want to put a lot of emphasis on the spoon. Well, take a look at the top of the spoon. It's dirty. It's been used. Now, I don't know why Mr. Jean would have put the spoon up that way. Perhaps there was a big piece of ice cream that was in the way. But you can tell this is where he's sitting, and this is the reason why. Number one, you heard how much he wanted to enjoy this bowl of ice cream. I can tell you as a big guy, when I put ice cream in a bowl, it's not going to sit there unattended. That's just a fact. Number two, you've got on the couch, you've got the center cushion that's open, you've got pillows on the right, you've got a blanket on the left. Next to the ice cream, you've got your remote control, you've got your laptop computer, and you've got your cell phone. Everything that he could possibly want is right there. That ottoman, when Officer Blair and Lee walk into the apartment, it's pulled up right to that center area as well. This was his nest. This was what he was doing. And when you asked the third piece of physical evidence, when Dr. Gwynn was on the stand and he was testifying about the trajectory, he said, absolutely. The bullet path that I found in the body is consistent with a person getting up from a seated position. And it absolutely is. For Botham Jean, who was sitting, and the TV would have been right where you ladies are right now, he would have been watching that. The disturbance would have come to his left and towards his front. As he is getting up to find out what that is, he is shot as he is saying, hey, hey. They're talking about how it's remarkable that he is able to walk a couple of paces. The doctor testified, absolutely, he would have had the ability to do some purposeful movement. There was no damage done to the spine that would have dropped Mr. Jean like that. He was able, because it was his intent to look and see who's coming through that apartment. He was able to take a couple of steps forward before his body failed him. That is the only explanation that fits with all of the physical evidence. The only other reasonable possibility, and I admitted this during opening statements and I embrace it now, was Mr. Jean hiding, getting down as low as he could to get behind that small 3-foot counter because he saw her coming in with a gun. Either way, Botham Jean was never a threat to Amber Guyger. Never. Justice needs to happen in this courtroom today. For over a year, there has been injustice and indignity. And Mr. Jean and his family have waited for a year for justice. You 12 people get to write the last chapter in this story. Although there's been injustice and indignity so far, you can restore justice to this case. You can say, Botham Jean, you did nothing wrong and you did not deserve to die. By your verdict, you can also tell her, you will be held responsible for what you did. And whether or not you want to accept responsibility, it's going to be forced upon you. And by God, in Dallas County, Texas, there will be a consequence for you walking in and shooting an unarmed, defenseless man. Thank you.